Her biography is a biography of firsts. The first woman from her school, Richmond High School, to go to Cambridge. Do you not get into Oxford?
I was on the waiting list to go to Oxford.
There we go. Confirms all my prejudices, I like that. The first woman appointed to the Law Commission. In 2004, she became the first and only woman law lord, the first woman deputy president of the Supreme Court, and then the first woman president of the Supreme Court. After the prorogation decision in September 2019, she was dubbed by some the Beyoncé of the legal world, which I think is a good thing, and had a double-page spread in Vogue, it says here. Congratulations. Lady Hale hails from Leeds, which, as you know, is a small suburb of Wakefield. Now, interesting, I mean, we have this group from Batley High School here today, and actually I want to start with them because they're a group of young women from a sort of very disadvantaged background, and I just wondered, I don't know if you said this to them or not, but what would you say to a group of people like that about how you achieve your goals and ambitions regardless of where you're coming from?
Well, I was more or less asked that question, and it's one I'm often asked, but by various different groups. And I start by saying, find something that you enjoy doing, because it's really, really important as a young person to find something that really enthuses you, that you like and enjoy, because that enables you to put up with the boring bits, you know, and there are boring bits in the law, but most of it is great, good fun. And if you enjoy it, well, then you will work hard at it, and if you work hard at it, you'll be the best you possibly can at it. But the reverse is also true. If you don't enjoy it, you won't work hard, and then you won't be the best you possibly can at it, and it'll be a... So there's a virtuous circle and there's a vicious circle. I didn't put it in quite those same terms, but that's more or less what I say.
Okay. I mean, it's unusual in this country, isn't it, for judges to write memoirs, and sort of even less common is the fact, I think there's a children's book about your life. What is it about your story, you think, that fascinates people so much?
Well, I don't know the answer to that. The children's book was the idea of a child of the woman who is chair of the Legal Action Group. And she had seen the book about Ruth Bader Ginsburg's life. And she apparently said to her mother, well, don't we have anybody in this country about whom a similar book could be written? You know, it was a picture storybook. And mother thought, oh, yes, well, possibly we do. I'll better go and ask Brenda what she thinks of the idea. And so it was a money-spinning exercise for the Legal Action Group, which is a cause very dear to my heart. And so, of course, I encouraged them to go ahead with it. And they got a brilliant author and a brilliant illustrator to do it. And it is a really lovely book. And I have read it to several groups of primary school children, and they've all enjoyed it a lot.
Wow.
So
sort of the ultimate accolade in a way, isn't it?
It's wonderful. It's absolutely wonderful, because it's not really about me. It's about a little girl from my hometown who goes with her class on a visit to London, and as well as going to the Eye and various other things, they come to the Supreme Court and they visit the Supreme Court. And of course, I walk into the cafe and we talk about the sorts of cases I do and the sorts of things that I believe in.
Actually, I don't know if you've read it, but Fiona Hill, who worked in the Trump White House, has written a memoir.
I know who Fiona Hill is, yes.
But it's well worth... I mean, actually, we've got an event with Fiona Hill coming up, so let me flag that for those of you who are interested. But her memoir is very interesting because she talks a lot about growing up in the North East, in a working-class family.
Well, she comes from Bishop Auckland.
Yeah. But in your book, you mention the fact that you have a strong attack of imposter syndrome when you first sat as an assistant recorder. And I mean, many in my profession, many academics, whether secretly or less secretly, suffer from exactly the same thing. And how do you overcome imposter syndrome?
Well, it struck me at various times in my life. You know, when I first went to the high school, when I first went to Cambridge, when I went to the Law Commission, I think possibly the most. We didn't call it imposter syndrome then, but you know exactly what it is. It is, what am I doing here? Can I really cope? To which I think my answer has always been, well, I wouldn't be here if somebody didn't think I could cope, because that's why I'm here. So it's my job to prove them right. And if I can't prove them right, well, then they were the ones who made the mistake.
I might try that myself, actually. Let's turn to the judiciary now and to legal matters. And on your retirement, one of your colleagues described you as a feminist, frank and fearless. Have attitudes towards women in the judiciary changed during your lifetime? And if so, how? And how far is there still to go?
Well, the numbers of women in the judiciary, of course, have changed quite dramatically, because the first woman High Court judge was appointed while I was an undergraduate. And I was only the 10th by 1994. So you could see that things have changed very dramatically in terms of numbers. As far as attitudes towards women in the judiciary, that's much harder to gauge, because I think that all women, when they start breaking into a male-dominated profession, have got to decide what style they're going to take. And the first two women High Court judges couldn't have been more different. The first one, Elizabeth Lane, looked and behaved and sounded as much like a man as she possibly could. Mm-hmm. Whereas the second was Rose Halbron. And Rose Halbron, nobody could ever be in any doubt, even if she was all dolled up in judicial robes, that she was a woman, and indeed a very beautiful woman with a very beautiful speaking voice, and she made no secret of her femininity. And I think that first women have often got to choose which of those styles they adopt. And there are risks with both of them, because obviously trying to behave and look and sound like the men is denying your femininity, and it's also not giving the message to the world that women can do it as well as men. But if you do let your femininity show, you can be accused of trading on it and being flirtatious, when actually all you're doing is being you and friendly. So both of these have got dangers, but you do, on the whole, I think, have to adopt. And I have always tried to be quite clear that I'm a woman. And indeed, my successor in my valedictory said that something was a symbol of swashbuckling womanhood. So I reckon swashbuckling womanhood is even better than being Beyonce.
Well, that's a pretty good testament, it has to be said. But so this is all linked to the question of the diversity of the judiciary. Does it matter that the judiciary sort of looks and feels a bit like the population over which it presides?
Yes.
Why?
For that reason. Because the judiciary preside over the courts. And the courts are, or should be, there for everyone. People should feel that the courts are their courts and that they're there to get justice for everyone. And they're not just staffed by a small elite group of people, beings from another planet, which it often used to feel like. And so for democratic legitimacy, I think it's very important that the courts are as diverse as it's possible to be, obviously consistently with getting people who know a bit of law and have judicial qualities.
And what would you suggest is the best way to get more women into the judiciary, or get more people from BAME backgrounds? Because there's a problem statistically in both areas, isn't there?
Women, it's hugely better than it was. I mean, absolutely hugely better. We're now up to 39% of the courts judiciary, 50% of the tribunals judiciary, though that includes a lot of fee-paid part-timers, so it a bit skews things. Probably over-represents women in a way. And in the High Court and above, it's only 29%. Right. So it's not as good as it should be, but my goodness, it is so much better than it was 20 years ago. And progress is being made. And the major progress has been recognising that there was a problem, not just thinking, oh, well, it'll all sort itself out in due course. Having the Judicial Appointments Commission independently, having a proper applications and recruitment processes, not the old tap on the shoulder. I mean, I did very well out of the old tap on the shoulder, thank you very much, but it wasn't right. And having proper merit-based assessment processes is the right way to do it. And it has resulted in there being more women. And the minority ethnic situation is pretty good in tribunals.
Okay.
In the tribunals, I was told by the then senior president of tribunals, so we're talking probably about 3 years ago, that the proportion of women and of ethnic minorities in the tribunals judiciary roughly mirrored the proportions in the working population of the appropriate age group, comparable age group, which I thought was a pretty good achievement. It's obviously going a lot more slowly in the what we call the uniform branch. Yeah. It's the robes-wearing courts, yeah. There is obviously a way to go. But of course, one of the difficulties with ethnic minority lawyers is that they're not all the same. There are many different ethnic minorities, and the barriers to advancement that each of them face are very different. So we can't just lump it all together and say it's a BAME problem. I think it's more subtle than that. And of course, the same is true of socioeconomic background, which is another dimension.
But would you favour a system of sort of more aggressive sort of positive discrimination?
I don't favour positive discrimination in the sense of you've got two candidates and one is better than the other, but you pick the less good one because they come from a disadvantaged group. I don't favour that because I don't think it does that person any good, and it doesn't do the rest of us any good. But what I do favour is all sorts of ways of trying to bring on people from less well-represented groups and recognise the merits that they do have and recognise potential. And so you have to find ways of assessing potential, which is much harder to do than assessing current achievement. But they're working on it, and I think they recognise that it is necessary to try and fish in different pools from the ones they've been fishing in. So there are all sorts of things that you can do to improve matters without going to that length of favouring somebody who's less well qualified or over somebody who is better qualified.
Okay, now over the last decade or so, we've seen a whole load of changes to the legal system, one of which is financial. The MOJ's budget is about 25% lower in real terms, I think, than it was in 2010. What's been the implication of that for our legal system, do you think?
Well, all sorts of things. If anybody's been anywhere near a court recently, you might have noticed how dilapidated they are.
I've never been in a court.
Well, you are to be congratulated.
Surprisingly, that might seem.
Yeah. No. No, you look like a respectable person to me. You might have been called for jury service. And then, I mean, my daughter's partner was called for jury service quite recently down at Southwark Crown Court, and she said the whole place was really a complete disgrace to a justice system that is self-respecting. So, you know, it's the whole court estate, the infrastructure. Too many courts have closed, so that the whole idea of local justice, where I come from in North Yorkshire, do you know, I come from Richmond in North Yorkshire. We used to have a magistrates' court in Richmond, and then they closed that, and everybody had to go to Northallerton, and then they closed that, and now I think they expect everybody to go to Harrogate. There is no way you can rationally get from Richmond to Harrogate by public transport. It's just... So local justice has suffered. Court sitting days have suffered. So the backlog that was well established in the criminal justice system before COVID made it even worse. And that was through cutting down on court sitting days. Of course, the lack of access to public funding for legal services for people who need it, the whole LASPO, large areas of particularly civil and family law being taken out of the scope of any sort of public funding. I mean, I can understand trying to restrict people going to court, but what is much more difficult to understand is restricting the first help and advice that everybody needs if they have a legal problem, which can usually nip the problem in the bud by sensible letter writing, phone calling, negotiation, and so on. So that's, I could go on.
Well, just to pick on a couple of...
You could get onto the prisons and the probation service, you know.
Just to pick on a couple of things. I mean, firstly, we've seen quite a few innovations because of COVID, not least things happening online. Do you think that might be a way forward to sort of addressing some of the problems. You talked about distance that
Yes,
people have to travel.
yeah.
I mean, do you think some of those innovations should be held on to going forward?
Oh yes, there's no doubt that there are quite a lot of things that we used to do in person and didn't need to be done in person. But on the other hand, we've got to hang on to doing in person those things that do need to be done in person.
Yeah.
I don't myself think that it's acceptable for a mother to be deprived of her children over the phone.
Mm-hmm.
And that has been happening. I think contested witness actions where somebody is trying to get at the truth, or indeed contested family actions where you're trying to get at the family dynamics, you really need to be in the room or reasonably closely in the room for the judge actually to be able to work out what's really going on. But on the other hand, a degree of separation is good in domestic violence cases, for example. Mm-hmm. So there are ways in which the technology can be usefully and creatively deployed, but there are some red lines, I think.
Yeah,
where
so it's not all or nothing.
No, it's not all or nothing. It shouldn't be all or nothing. And the other thing, of course, that would be wonderful if we could do is digitise court processes to a greater extent than has already been done, so that a litigant in person, can go on a website and sort of type in, "This is my problem," and be told, well, this is what you need to do, and you fill in this form here, and then tick these various boxes, and then it leads you on to the next thing and tells you what documents you've got to file, and when the other side says something, it tells you what you do in response. I mean, that is not beyond the wit of person. It's just very expensive to set it up. But we could do an awful lot of that, and it would save huge amounts of the costs of the justice system.
Yeah, it would save money down the line, wouldn't it?
Yeah, it would.
Definitely.
But it would cost a lot to do it in the first place.
Yeah. You touched on legal aid as another aspect that has been a sort of victim of the sort of cuts that the legal system has seen. Are there tweaks that can be made to improve access to justice? I mean, what would you like to see changed?
Well, I think, and I do think that every Secretary of State for Justice, since the major cuts happened, has been trying their best to claw a bit back for the system. But I think the most important thing is to try and find some way of getting people in initial civil and family problems access to help and advice and help. As I say, writing the odd letter, or email, of course, lifting the phone, talking through, well, why are the rent arrears? It's because the housing benefit hasn't come through or hasn't been properly calculated. Can we sort that out? And can we stave the landlord off for us while we sort that out? That sort of thing. With family problems, sitting down and working out what people really want, telling them what the court's going to be interested in. Mm-hmm. So there's no point in going to court to fight over that because the court's not going to be interested. Let's see what you say about the things the court is going to be interested in. And then we'll talk to the other side and see if we can hammer something out. Okay. That's what family lawyers used to do all the time. They didn't take cases to court unless they absolutely had to. What they did was sort things out. And it's getting back to a way of enabling both parties to have the help that they need to sort things out.
Now, criminal barristers, of course, have voted to go on strike.
You mean barristers in the criminal justice system?
That's exactly what I meant, yes. Me and lawyers. Those people you just mentioned have voted to go on. So what's your feeling about that? Do you think they should? Are you supportive?
I think I'd rather dodge that question. Because, I mean, the one area where there still is some legal aid is in the criminal justice system, because the government knows they've got to supply that. That's part of their international commitments to supply that. But, of course, that doesn't mean to say that they've got to supply it at any particular price.
Right.
And so there are bound to be disputes about the price that's paid. And there isn't a lot of doubt that it's very difficult to sustain a criminal justice practice. If you're in the general standard run of criminal cases. I mean, there are certain highly paid cases, certain big money cases where people can make a lot of money, but your ordinary barrister practicing in criminal law is going to find it very hard to make ends meet.
Yeah. Okay.
And so I have sympathy for their cause. Whether going on strike is the right way to advance it, that's what I don't want to comment on.
OK, that's fair enough. That wasn't really a dodge, that was an answer, so that's fair enough. Now, obviously, when it comes to sort of big questions of constitutional law, we've seen a sort of unprecedented period over the last 5 or 6 years of sort of, in some cases, what looked like open warfare against judges, the enemies of the people headlines and things like that. Have you been surprised by some of the ferocity of the attacks on the judiciary, and whose job is it to stand up for judges? Was it your job when you were at the Supreme Court? I mean, who speaks for the judges?
Oh, well, the member of the government who has a statutory duty to uphold the rule of law and the independence of the judiciary is the Lord Chancellor and Secretary of State for Justice. And by and large, they've been pretty good at it, by and large. There was a script that could so easily have been written after the famous Daily Mail headline.
Yeah, so that was Miller 1.
Enemies of the people. And it goes something like this. We have a free press in this country. You are entitled to do what you've done. It's not against the law. But it's my task, as the member of the government who is sworn to uphold the rule of law and the independence of the judiciary, to tell you that you are wrong. These are not enemies of the people. These are judges who have sworn a judicial oath to uphold the law, and that's what they have been doing. And if by any chance they have reached the wrong result, well, then the Supreme Court can put them right. Really simple, not difficult to do, because it accepts that we have a free press and freedom of expression, but it says what they have said is not accurate. It's unfortunate that didn't happen, but it was all right. It did sort itself out by the time it came to us. I was really quite impressed. You know, the press are very, very clever. The Miller 1 case was 11 judges, and it was 8-3.
Yeah.
Now, we didn't disagree about the principle, which is that the government can't change the law. Only Parliament can change the law. The disagreement was whether the European Communities Act, 1972, contained in its own wording the seeds of its own destruction. And there was a perfectly respectable argument that it did. It just didn't make sense to 8 of us that this is what Parliament was doing when it introduced a whole new source of law into English law and so on. So what, of course, the Daily Mail did was that it had same-size portraits of the 3 dissentients with the headline, Champions of the People. Wasn't that clever?
Do you think things are qualitatively different now? I mean, I remember under New Labour governments, ministers talking about unelected judges as if this somehow affected their standing.
Well, I think that, I mean, things did get really febrile during the whole Brexit debate, and so feelings were heightened. Even though the judges weren't deciding on Brexit, that wasn't what we were deciding at all. But people didn't see it in that way. And I think the other thing that's happened, which wasn't the case in the olden days, is social media. And most of the judges I know don't do social media at all, but of course politicians have to. And so it's tricky. We don't know what's going on in the Tritosphere, really, and that's probably just as well, because we have to get on with the job that we're sworn to do. But so I think those 2 things, one is temporary, that's largely gone now, but the other is permanent, have sort of upped the ante in terms of possibly attacks on the judiciary. But it's happened before. We have to carry on doing the job.
I mean, it's interesting what you say about Twitter, because I wonder sometimes whether actually part of the response to the problem is if judges became more accessible, better known, you know, under you, the Supreme Court rose as a sort of in prominence as an institution. I wonder whether actually sort of lifting that veil of secrecy a little bit would help. Rather,
well, I don't think we're secret.
No,
come on.
But just communicating.
We're not getting on to family courts here, but let's. Well, the Supreme Court does tweet. It does have a Twitter feed. It's just the individual judges don't.
Yeah.
And I think that's probably wise, one way or another. I'm all in favour of as much transparency as we can possibly do. The Supreme Court has been filmed since its outset. We were exempt from the ban on filming in court from the outset. We were set up with cameras in each of the courtrooms, and very soon, as soon as we could, we live streamed our proceedings. And sometimes, of course, in a high-profile case, it's also televised, but mostly live streamed. And you can now go back and look at all of our really boring hearings. Because, of course, most legal argument is, unless you know the documents, you know the case, you know the people, is pretty tedious. But I still think it's important that it's out there, the public can watch, they can see. I would like us to be able to publish the core documents in the case, but there are kind of data protection issues there and cost issues there, which have so far made that difficult to do. But really, I think they should be out there as well, so that people can follow the case from the written arguments as well as from what they're seeing on the screen. So I'm all in favour of as much of that as possible, and I think it's had a beneficial effect. I actually think the televising of both the Miller cases did have a beneficial effect, because people could see that we were arguing about serious constitutional issues. We were not arguing the pros and cons of Brexit. We were arguing about what the role of Parliament was and what the role of the government was in both cases.
I mean, do you think citizens understand the law and the role of the law and the place of the law sufficiently well? I mean, some people suggest that actually what's missing here is a better educated population. You should do civics. People should be taught this sort of thing more systematically at school. Do you think they've got a point?
Absolutely certain they've got a point. I think in most other countries, the people do learn in school the basics of their constitution, what the functions of government are, who does what, and what the relationship between them is, and what the fundamental principles are. I think most people do learn that in school, but it doesn't seem to happen in our own schools, and I think it definitely should.
Okay, there are some people also who've suggested that one way to get around this problem for those who see the judiciary as somehow illegitimate is to have greater political say in the appointment of judges. What's your feeling about that? Well,
it's really interesting, isn't it? Because until the Judicial Appointments Commission took over, the appointment of judges was the responsibility of the Lord Chancellor. In other words, it was solely in the hands of a politician. But it has not been thought that the judicial appointments were actually made on political grounds since the Second World War. I mean, I got my first 2 judicial appointments from a Conservative Lord Chancellor, and my next 2 from Labour Lord Chancellors, and then the final 2 on a merit-based application process, not the tip on the shoulder.
Okay.
So, I mean, I think that demonstrates that the system, even in the days when it was done by the Lord Chancellor, was not motivated by party political considerations, which I think is really, really important that it mustn't be. And it's a rather secondary consideration as to who does it. But I do think that the independent merit-based system that we currently has improved the diversity of the judiciary. And there is a genuine issue as to whether the role of the Lord Chancellor has now been too diminished. Most of my former colleagues would be horrified to hear me say that, because they are much more comfortable in a system which is completely divorced from politics than in one which had really any political involvement, particularly now the Lord Chancellor is a member of the House of Commons and a much more active politician and not a senior lawyer. But I do think there is a bit of a problem or possibly a problem, and I think the UCL Constitution Unit has highlighted this, of a sort of lack of political buy-in to the justice system, because there's no longer that
link.
To which I tentatively suggested some time ago, to much horror, well, why don't we expand the 5-person commissions who recommend the appointment of Supreme Court justices by 2, a senior politician, both from the government and from Her Majesty's loyal opposition, so that it wasn't party political, but you actually had some parliamentary buy-in to the process.
Okay, the political scientist in me wonders that at a time when politics is as polarised as it is now, whether your experience that you had with both Tories and Labour would be the same now, because I mean we live in, you don't have to answer this, but we live in an era when...
We don't know, do we? No, we don't.
When, you know, the government's interested in museum boards.
Well, that's why I say that even reintroducing that bipartisan element of political buy-in is very controversial amongst all the judiciary, who are much more comfortable with the present setup.
Now, one of the things the previous panel today talked about was whether or not we need or should have a written constitution. And I just wonder, purely from the perspective of the judiciary, whether the role of the judiciary would be made easier if we had that kind of written text.
Well, I think the answer to that is almost certainly no.
Okay.
In most places where there is a written constitution, the judges have the power to strike down unconstitutional legislation. That's a feature of written constitutions. In fact, I can't instantly think of one where that isn't a feature of written constitutions, although I did listen to some of the discussion and it doesn't have to be. But I don't think the judges in this country want to be able to strike down provisions in acts of the UK Parliament. I think they're perfectly comfortable with the balance that we have between the sovereignty of Parliament and the rule of law at present. That's what I think. So, and the second aspect of this is that we are familiar with written constitutions in the Judicial Committee of the Privy Council, of course, where we still have jurisdiction over a couple of dozen countries which do have written constitutions, and so we have experience in trying to interpret them. And the really difficult demarcation questions that arise don't necessarily get answered by any written constitution. There are always gaps. They don't answer every problem. I don't know a written constitution that would actually have answered Miller 1 or Miller 2 in so many words. It would have to be written into, you know, how does the power of the executive interact with the power of the legislature, and what is the balance between. And although they tend to say there shall be a legislature which shall do this, and there shall be an executive which shall do that, they wouldn't answer those really difficult demarcation questions. So I don't think it would make life any easier. No.
When it came to Miller 2, did you realise at the time that you were sort of making political history that this would lead to the sort of reaction that it did lead to?
Well, we knew there was an intense public interest.
Well, there was a crowd outside.
Well, there was a crowd inside, and a crowd outside, and a crowd outside. So yes, of course, it was intensely interesting. I think you have to get on with the job without thinking about what the reaction may or may not be to what you decide. And so you have to be largely oblivious of that.
And was it helpful that Miller 2 was a unanimous decision?
I think so.
I mean, as compared to the experience of Miller 1.
Yes. Well, I understood entirely where the minority in Miller 1 were coming from. But no, I do think that it was a very good thing that we were unanimous in Miller 2. After all, everybody knew what the argument was, because we'd got a case from England saying one thing, and we got a case from Scotland saying the opposite. They couldn't both be right. So we had to choose between them. And so everybody was fully aware of what the argument was. I mean, we agreed with Scotland in the result, though not exactly the same reasoning, but quite close to it. It was a case that we didn't have any choice over. We did actually have to decide it. That's one of the things about judging. You know, you got to decide.
Now, I mean, one of the outcomes of the 2019 election was that we got a government that seems to be committed to reform in some ways of our judicial system. So one way
change?
is, replacing the Human Rights Act, for instance, is something we expect to be in the next Queen's speech. What do you think that might mean? What is your sense of that?
Well, I've read the consultation paper and I have responded to it. So I'm not sure I want to do anything other than express what I put in the consultation paper, which is we've got a Human Rights Act which works perfectly well at present, and there are possibly one or two comparatively minor changes that might be made, which were recommended by the independent Human Rights Act review, which did a very thorough job of consultation and thinking and workshopping things, came out with some recommendations which I think make complete sense. Okay, do that. But replacing a whole Act of Parliament with a new one is a recipe for decades of litigation. It's also quite an unnecessary litigation because the government has said we're staying in the European Convention on Human Rights, which means that they've got to allow individual petition to the European Court of Human Rights in Strasbourg, and they've got to abide by the decisions of the European Court of Human Rights. So why replace what we've got at the moment, which is consistent with our international obligations, doesn't seem to have done a lot of harm, with something that could risk actually causing more trouble than it's worth.
And when it comes to judicial review, do you see any potential advantages for the judiciary under the sort of government's plans to reform judicial review?
Well, under the current bill, they are suggesting, as I understand it, and I haven't looked at the most recent version of the bill, so there may be things in there that I haven't got hold of yet. They're suggesting that it should be possible to have prospective quashing orders or to delay the effect of a quashing order. Now, I think we all think that's very sensible. Doesn't mean to say you haven't got to use those powers, but there sometimes are cases where you've found that something is unlawful, but it would be extremely inconvenient for everybody if instantly everything that had been done under it had to be undone. And so there will be circumstances in which that is a useful addition to the things that the courts can do.
Okay. Well, you were absolutely right when we talked beforehand, as I got through about a quarter of my questions in the time.
Sorry, have I been answering too long?
No, not at all. You've been very pithy. We just had too many questions. But time has caught up with us. It is now past, and I know it's been a very, very long day. So on behalf of all of us, Lady Hale, I just want to thank you so much for taking the time to do this. It was absolutely fascinating. And to all of you, thank you so much for being here today. As ever, if you've got suggestions about things we could be doing, events you'd like us to put on, reports you'd like us to put out, just get in touch and tell us. And I very much hope we will see you at our next event, which is, this is the memory thing again, in April sometime. There we go. As on the screen, I can't even turn that far, so there we go. I very much hope we will see you all.
Unlocked with Fiona Hill.
Yes, and Unlocked with Fiona Hill.
Yeah.
But for now, thank you all very, very much indeed.